Welcome back, class. We're going into contracts now. I touched a little bit on contracts at the end of the first half of our semester, going into exam one. Now we're going to focus on contracts pretty much entirely for the remainder of the semester. And I hope you're as excited as I am about that, because business really is contracts, and business law is generally contract law. I mean, I talk so much about the Constitution and how important ethics and criminal law and torts are, but essentially business comes down to a series of contracts. When you go to McDonald's, for example, and you drive up to the drive-thru, you create your order, and that's the inception of a contract, and then you receive the benefit of your contract when you wait your turn and you get your food and you pay your money. That's how that works. That's a contract. Just like everything else in life, and our relationships with family, our relationships with friends, our relationships with coworkers, they're all actually a series of contracts. And I think after you learn about contracts, you're not going to be able to shake that, but it's going to help you when there's disputes, when there's what we call a breach of a contract. You're going to be able to use the lessons that you learn in Business Law 1 to address those, or to think about them. You know, you might have been wrong in the situation, and you'll, have a command over the concepts that we're going to learn about contracts. So, general perspectives. We're covering Chapter 8 right now, which is just an introduction to contract law. And when we think about the role in modern society, I just told you how everything as simple as going through the drive-thru is sort of a contract, and other things like that. But I want you to think of a meeting of the minds, okay? So a contract is generally going to be one person offering something, another person accepting it, or a series of those types of contracts. And when ultimately, if a court has to review it, they're going to look, when it comes to the validity of a contract, whether it existed the way one party claims that it does, or enforcement of a contract, when someone alleges a breach of a contract, they're going to look and see whether there was a meeting of the minds. And that term actually came from a local law student here at Cornell University, Cornell Law School. And it was Samuel, where is it here? I guess I didn't write it down. I looked it up a little bit. I think his name is Samuel Willison. And he was writing a legal paper about contracts, and he came up with that term, meeting of the minds. And I ran across it in the last few years when I was negotiating a contract for the sale of a restaurant. And I had criticized my adversary, the attorney representing the buyer. And I said, hey, these guys have a deal and you're messing with it. And I remember him writing back saying, well, it sounds like they didn't have a meeting of the minds. We ultimately got everything we wanted, and that attorney didn't get anything he was pushing for. But I still, it drew me back to law school and learning about that concept. And I think it's an important way to think of contracts, that it's a meeting of the minds, and that's the way courts are going to look at that. So it's integral to our system of capitalism. Whether you agree with everything about capitalism and socialism, that ongoing argument or not, there's a spirit of promoting business, and I hope that's why you took this class. And certainly the law as it develops about contracts is necessary for business to take place. If we don't have confidence in our legal system that enforces contracts or remedies breaches, then people aren't going to have the confidence to do business with one another. So that's why it's so important. And we're going to start with the sources of contract law. I may have touched a little bit about this going into our last exam, but basically we have the what's called the restatement and it's called the Restatement Second because it's been amended, and that's where we are now. We're at the Restatement Second. And, we talked about how law is developed and how precedent is created, and we follow common law. And this is sort of a source of law where American attorneys and judges and law professors got together and they formed the American Law Institute, the ALI. And their goal was to take all of this case law that they've been studying and citing when there's contract disputes and business disputes, and trying to consolidate it into a source that attorneys can refer to for consistency. And that's called the Restatement First. And the American Law Institute, they got together in 1923, and then they published their Restatement of Law in 1932. And they published the Restatement Second in 1979, and that's what we're working with these days. The other source of contract law doesn't really come from case law. It's more statutory. And all 50 states have adopted it. So this is the Uniform Commercial Code, and we can count on that when we study and practice business law. We can count on the rules that make up the UCC because, again, the American Law Institute got together in 1942, and they got together with the American Bar Association, which is a voluntary bar association of all of American lawyers if they want to participate. And they created the Uniform Commercial Code, and all 50 states eventually adopted it. So when we talked about federalism back in chapters, in the early chapters, just keep in mind that there's a slight distinction here. This is not a federal statute, so it didn't get approved by Congress. The president didn't sign it, but all 50 states have agreed to it. And there's an international version where more than 40 countries have agreed to it. But what it does, the usefulness of the UCC, is that as a business person, you can rely on certain things. Certain type of contracts have to be in writing. Certain type of contracts have to have a deposit or honor a deposit, or things have to be shipped a certain way, or a certain person's responsible, a certain party is responsible if something's damaged in the course of a trade during a contract. You can count on all these things. And in Chapter 8, you can see the outline of the organization of the UCC. The articles are outlined there. I think it's a bit advanced for Business Law 1 to know all the different parts of the UCC, but we'll visit different parts of them as we finish the rest of the chapters and the different parts, the different concepts involving the study of contract law. All right, now, some basic things, an overview. In a contract, we have mutual assent. So at least there's going to be two parties. And assent, by that I mean acceptance, by consent, acceptance. Assent has its own meaning when it comes to contract law, but that's generally what it means. And in Chapter 9, we'll go into just very basic offer and acceptance of that. Then there's another layer of that. Is it real assent? And in Chapter 10, we're going to talk about some exceptions to, or some factors that courts will visit and consider whether there was real assent. For example, duress, undue influence, misrepresentation, or mistake. So, or incapacity. So if someone's too young to accept a contract, for example, that contract's going to be invalid. So, and then Chapter 11, we're going to talk about consideration. And in the United States, all contracts have to be quid pro quo. We talked about quid pro quo before, the Latin meaning this for that. And all contracts in the United States have to have a this for that. There has to be some the consideration for the benefit for that. And then in Chapter 12, we're going to discuss legality of a contract, and we'll talk a little bit more about how the UCC affects that. And then we've got we'll move into the last quarter of the material in the remaining chapters, but I want to focus on those concepts right now. And when we talk about the basic taxonomy of a contract, we have to have explicitness. So in order for the parties to be engaged in the contract, there has to be an express contract, has to be spelled out directly. Okay, so for example, $5,500 for a car on Monday at 10 a.m. That's where the exchange is going to happen in the sale of a car. And under those circumstances, an email can be generated. It doesn't have to be a signed piece of paper. It can even be done by a phone call. I would say as a business person, you're better off memorializing things. And there are certain contracts that need to be signed, certain contracts that need to have ink signed. There are certain types of contracts that can be electronically signed. And then generally there is no requirement for signing, but we'll see when we go through the UCC, there are certain things that have those requirements. But we've got explicitness that can be implied in fact. So certain types of contracts can be implied based on someone's conduct, or there's evidence of their intent, what's going on in their head. We talked a lot about that in criminal law. Well, now we're talking civil law, and it's easier to prove intent because of the standard of proof that we've been learning about. It's preponderance of the evidence when we're talking about civil court. So just more likely than not. Whereas we talked about criminal law, the standard of proof is going to be beyond a reasonable doubt. So it's a stronger burden of proof. But here when we're talking about contracts, we're civil law and we're preponderance of the evidence. So keep that in mind. Let's see. We've got something called a quasi-contract, or sort of implied in law. And we're going to talk about the concept of unjust enrichment. So for example, if someone accidentally delivers you a package and it's a fairly expensive item, and you see that it's not your name on the package, or that you should know that it's not for you. Well, someone can sue you for unjust enrichment, even though you don't have any contract with anyone. If you take advantage of that mistake, there could be a contract cause of action. So we'll get into something like that in some cases. Mutuality, think of the contract, or the concept of mutuality in a contract. So again, quid pro quo. So it's very important in US law that that element exists. And then there's the unilateral contract. And when I use the language unilateral or bilateral or multilateral, unilateral means one. So think of a unicycle as one tire, or as a bicycle has two tires. So unilateral will be a contract that's basically open for acceptance. It's only one party at that point. And one example that's in the book, and we'll be revisiting as we go on in these chapters, is, for example, someone puts an offer out there and they say, I lost my dog. Here's a picture of my dog, and there's $1,000 reward. And I'm sure most of you have seen something like that before. So that's an example we'll come back to, but that would be a unilateral contract at that point, but it becomes bilateral once someone starts investing in trying to find the dog, or finds the dog. You can consummate that contract. Then we're going to study enforceability. So sometimes contracts are void when they begin. So something illegal, like someone hires a hitman to kill somebody. Obviously, that's not an enforceable contract, and it's void. Then there's voidable. So, think about maybe someone under 18 years old buys a car. Well, actually, someone under 18 can't really engage in a contract. Now, that purchase can go on and nobody has a problem with it. So it's voidable. If the person claims it as a defense later, that contract can be ruled unenforceable because of the person's age. It's voidable, but not void, whereas an illegal contract could be void. Then there are certain things that are just unenforceable. There are contracts like that. So you could have the statute of limitations expire. We talked about that when we talked about litigation and in the early chapters. And another example would be in the case of a bankruptcy. So we're not going to talk a lot about bankruptcy in Business Law 1, but you know, contracts can be ruled unenforceable by a bankruptcy court. And I think it's important that you do understand why bankruptcy exists for a business person. And again, in the American economic system, we want to promote entrepreneurship. So we want people to take risks, because generally we're going to come out ahead when we promote business, when we create an environment where that benefits business people. And bankruptcy reinforces that. So we don't have a debtor's prison here. In US history, we've had this bankruptcy system. And again, just so you remember, bankruptcy is strictly in federal court. States don't handle that. So if you think about it as a very American, very federal kind of concept, and it's a way to protect people. All right, some terminology that you need to know is when we talk about contracts, we have, for example, an offerer, someone who makes the offer, and an offeree, the person who the offer is made. We have a promisor and a promisee. So sometimes you can have multiple labels that you can put on people in a contract, but these are general ones. Obligor and an obligee. The obligor is the one who makes the commitment, and they have an obligation to complete that. And an obligee is one to whom an obligation is made. Transferor is the person who transfers something. Transferee is the person who gets something. So I wouldn't worry too much about these terms. And now that we have Google, you can always look them up if you see them in a contract and you're not sure which party it's talking about. Like a mortgage, for example, can be a little confusing. Who's the mortgagor? Who's the mortgagee? All right. Now, going into the cases at the end of Chapter 8, the first case we're going to talk about involves an implied contract. So I talked about that just a few minutes ago, and we talked about how contracts have to be explicit. And there's a question here whether the contract was explicit. So we're in 2004 in the state of Iowa, and the city of Muscatine, or Muscatine, I'm not sure how you pronounce it. In any event, just like everywhere on Earth, people die and the bodies need to be dealt with. And we're talking about an undertaker here is the defendant in this case. And the plaintiff, Rogers Backhoe Service, contracted with the undertaker. The undertaker already had a funeral home, and he wanted to build a crematorium. And the crematorium is where, of course, bodies are burned and turned into ashes. And he wanted to offer that additional service to his clients. And of course, the city had interests in giving permits for building that type of facility. I struggle to think of other businesses that might have more regulation. You know, obviously garbage disposal would be way up there, or anything dealing with chemicals, but of course dead bodies, it's up there. So initially the undertaker, went and got the permits. He used the local business association to help him. And he contracted with Nichols Backhoe Service, the plaintiff in the case, to basically create an area which would be a foundation for the building. So the early stages of construction of this. And the issue in this case has to do with runoff from the parking lot. So when it would rain or snow, there's melting water, and the initial proposal was that the water would run off into the streets and into the sewer system that the city had. And the city said, okay, that looks good for now. And then someone realized that underneath the ground, there was a subterranean sort of sewer tunnel. And the city said, hold up, we're not going to give you your permit until you at least try to dig into that system so that the water doesn't go off into the street. And in that system, we want you to see if you can plug your drainage right into the system that's approximately, I think they thought it was 14 feet under the ground. It ended up being a little bit deeper than that. And Rogers backhoe service, or Rogers backhoe service said, well, we have to follow the orders of the city, at least try to dig in there. And according to the defendant, they said that they didn't give permission for Rogers to do that, and they didn't want to pay them for that service. And what ended up happening was the city said, all right, well, it looks to us like you're not going to be able to get into that sewer system from that angle, or you're not going to be able to get through that wall, or whatever the case may be. The city said, okay, at least you tried. Now you can use our regular sewer system. So there was that bill for about 3 days worth of labor in digging it and then filling it back up. And the undertaker, Nichols, said, we're not paying that. So then Rogers Backhoe Service sued Nichols for that part of the project that they didn't pay for. And the trial court said, we agree with the undertaker. They didn't get any benefit from that 3 days of excavating. So they shouldn't have to pay you. There's no contract that says in writing that you had to do that. But Rogers Backhoe Service said, well, it's an implied contract that we have to cooperate with the city to get the permits, etc. And the trial court did not award them that money, but they appealed the case. So now we're talking about, the court systems that we've been learning about, when an appeal is and when a trial is. And now the court doesn't look at issues of fact, they only apply issues of law at the appellate level. And what they did was they, let's see, in this case, the middle court, so, sorry, the trial court ruled in favor of Rogers, but the appellate court reversed it. All right. And they said that there was no benefit to the undertaker, to Nichols. And then Rogers, the plaintiff, wasn't happy with that, and they went to the highest court in Iowa, and the highest court then reversed the middle appellate court and said that there was a benefit, saying there was an implied contract. And the benefit was that, but for Rogers Backhoe Service trying that and appeasing the city officials, they would have been at a stalemate. Okay, so if you all know what a stalemate is, here's my fancy chess set. These are the kings here, and basically they couldn't kill each other because they couldn't move forward. They couldn't take the other side, and the game just is at a stalemate. And that's where this business transaction would have remained if Rogers Backhoe Service hadn't done what the city wanted. So there was a benefit to the defendant in the case, and that's ultimately what the appellate court decided. And that has to do with an implied contract. You can see those. The next case we're going to talk about is mutuality of a contract. So here you've got a case where a unilateral contract was enforced by the court. And the case comes out of Alabama. It's South Trust Bank versus Williams. There are actually two parties in the case. There's the bank, so that's one party, the plaintiff in this case, because Williams and Daniels are the other defendants in the case. And basically they're going after him to compel an arbitration clause, which was a unilateral contract. So if you've ever had a credit card or a debit card from a bank, a lot of times they will send you these notices saying that there's an important change in terms. And if you think about it, they're kind of just telling you that there's a change in terms. It's not like they call you and say, hey, is it okay if we change terms? They're just telling you that's the way it is. And you're not signing a new contract, you're not talking it through with anyone. However, what you think about here is that when you make another purchase after you receive that terms and you don't call the bank and say, I'm canceling, you're agreeing, you're assenting. The contract, it was unilateral when it was sent to you, but it becomes bilateral as you express your agreement to that. You keep using the card. Basically, Williams and Daniels, they're two people who have the cards, and what they're upset about is that the bank is giving them overdraft charges in a particular way, and the way they're doing that hurts the creditors, the person with the account, people using their overdraft fees. So basically, what happens is their account is depleted to $0, and the bank, when that happens, if it hasn't happened to you, they charge a fee, and it's supposed to be a deterrent. They want to stop you from spending more money than you have, so they give you these fees, and it can be it's like $35. Maybe it would be a general price, or maybe it's up to $40 now. But for each purchase, even if you go $2 over your $0, or sometimes you have overdraft protection and it doesn't kick in until after $1,000 of credit, whatever the case is. In this case, the bank did it in a particular way, and they were basically, if you made 10 purchases beyond your zero balance, they would subtract the highest ones first. They would pay those first. And if you think about it, it's kind of arbitrary how they do that. And the problem is if maybe you had $500 in your account and you paid $800 for a washing machine, and so now you're $300 out. And then, but that day, maybe you bought a cup of coffee in the morning, you bought a lunch, dinner, maybe you bought some movie tickets, whatever, in the evening, and you made these different purchases. Well, what they did was they would pay off that big one first. Then there'd be several charges beneath that were smaller, and each one of them gets one of those fees, one of those, $25, $40 fees, whatever it is in your contract. And that hurts the consumer, the creditor, because if you had $500 in your account, you thought you had $500. If you bought a cup of coffee, that cup of coffee is going to cost you $2. However, if the bank subtracts the $800, well, now that cup of coffee is going to be $2 plus the fee. So $42 cup of coffee. Your lunch maybe costs $10. Well, it's going to be $50 if you're borrowing from the bank and you have less than $0 in your account. And those movie tickets, well, those are pretty expensive to begin with these days. But, if it was maybe $30, you're talking about an $80 ticket movie that day because of the way the bank is enforcing these. So anyways, those defendants sued, and then the bank countersued and said, no, we sent you an agreement saying that you couldn't sue. So basically, those overdraft fees, that is a bad way to do business, and a bank can, or a court can overturn that and fix that contract. But in this case, the court said, well, what we're going to do is we're going to consider that there was this arbitration clause. So they sent the parties, if they have a disagreement, they're supposed to go to arbitration. And nobody agreed to it, but they kept using their card. And so that basically created a assent where there was a unilateral contract. And also another lesson here is that generally courts and the law favors arbitration, because courts don't want to have to do work when they don't have to. And if there's a contract that you're going to go to arbitration and you ignore that and you sue someone, the courts are always going to want to enforce an arbitration clause. So that's what happened in this case. All right, the last case in Chapter 8 is Woolley versus Hoffman. That's a case from New Jersey back in the 80s. and that has to do with at-will employment. And again, it's a unilateral contract because we're talking about a case where Woolley, the plaintiff, was given a handbook when he was hired. And in the handbook, 5 out of 8 of the pages, so it's a little handbook, and 5 out of 8 of the pages just have to do with termination. So there's there's points in those 5 pages that have to do with being terminated for disciplinary or for poor performance or for retirement. But there's nowhere in those 5 pages that says anything about just being fired without cause. And we talked about this a little bit, that generally the law is we have at-will employment. You can be hired, you can be fired. It's up to both people. They can walk away from a job. There's that conventional 2 weeks notice that you give, but there's no law that says that you have to do that. That just protects you later if you have to get a job reference, and if your employer says, oh, they just walked away from the job, well, that's not going to help you as a reference. But if they say, oh yeah, that person gave their 2 weeks and they were a good employee and they they didn't have to give me 2 weeks, they gave 2 weeks, it makes you look good in the future. But there's no law that says you have to do that. And then I want you to think of that the general law is at-will employment. So there's no requirement that someone follow a procedure. However, when you, as an employer, give a handbook to the employee, they can rely on that to some extent. And in Woolley's case, he lost at the trial level. The court said this is just a unilateral, unenforceable handbook. However, when Woolley takes it up through the appellate process, they changed it. So he lost at trial, he lost at the appellate level, and then the highest court reversed the other courts, and they said, no, this handbook actually creates an enforceable contract, because if you look at the record in the case, again, this is the appellate court, they don't have a trial, they just look at the record, and they looked at the record and they said that, he was promoted in 1977, he was promoted again in 1978. They followed this evaluation process, and then suddenly Woolley apparently wrote a report about the problems they were having with the pipes, and his supervisor didn't like the report. And I imagine that, this is my imagination, not in the book, but it probably costed the company, it was going to cost them a lot of money to fix the problems that Woolley pointed out. And so rather than spend all that money, they said, let's get a second opinion, and this guy's terminated. This guy's he's done. And so, but Woolley said, you know what? I'm doing everything the way that is outlined in the handbook, and I wasn't given any warning. If I knew that my performance wasn't acceptable, I could have moved on to another job, things like that. And that's what the court was considering, that actually this handbook, there's nothing in there about just getting fired. And if you think about it, the court basically was saying, this is the highest court in New Jersey, so lawyers are paying attention. And they say, all you got to do is just put some language in your handbook and say, there's also, you can be fired without cause. Without that language, though, Woolley, the plaintiff in the case, had a reasonable expectation that if he followed everything in the handbook, he didn't have to worry about getting terminated. So, his report could have been adjusted, something like that. But that's the end of chapter 8, and we will get into more concepts as the remainder of the chapters develop. Thank you for listening and watching.